Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. Today we focus again on the issue of labor relations, which are becoming a deep divide in the United States, and hopefully not falling on blue-red lines, but there's certainly a divide. And with me to discuss this, my guest again this week, Bob Sullivan, and he is with R.L. Sullivan Consulting, LLC. So thank you for being with us, R.G. Sullivan. Make sure we get that correct. You're a labor and employment consultant and with expertise in this area for more than 20 years. And Laura Lee Blake with the Asian American Hotel Owners Association, who serves as Vice President of Fair Franchising, Government Affairs, and General Counsel. Thank you both for being with me today. This has been in the headlines in a way that I'm not sure we've ever seen a labor issue in the headlines, and that is the case of Boeing. You've probably heard what has happened. I'll lay out the real basics, and Bob, you can fill in all the nitty-gritty details. Boeing Corporation, who of course operates mainly out of Seattle, Washington, has decided to expand their operations, and they already have operations in the state of South Carolina. They had planned a pretty large investment there, and in steps the National Labor Relations Board telling a private company that they cannot open a new plant in the state of South Carolina. Not a new plant in some foreign nation, but a new plant in the United States. This, of course, has caused great consternation for many people, particularly those in South Carolina, but I think this has kind of brought to head this incredible issue of the strength of the National Labor Relations Board and what kind of policy making they are now engaged in.
It really is amazing to see. Boeing, we're not talking about moving existing work from the Seattle area to South Carolina. We're talking about everyone in the Seattle area continuing to work on existing work, and Boeing wanting to bring in a new line of production and do that in South Carolina. What the National Labor Relations Board has done is to say that they believe Boeing wants to relocate to put the work in a non-union facility in retaliation for prior strikes in the Seattle area, which they contend violates the law. So the board has taken the very unusual step of suing in federal court, trying to force Boeing to put the work in Seattle and have it done by the union workforce there rather than the non-union workforce in South Carolina.
And apparently I read an article that included a reference to a May 10th NLRB internal memo in which they basically admitted that the board now wants to, quote, give more power to unions over employers, their investment, and management decisions. So this goes beyond the original intent of a union having some influence over the negotiation between an employer and an employee, to the point of saying, not only do we want to negotiate our decisions between us, we want to determine what you do with your entire business, what you're allowed to invest in, where you're allowed to create new jobs. This seems to go far beyond any rational expectation of a labor management relationship.
And it's even more than that, Chip. The General Counsel has issued a memorandum to the regional directors, and the board, think of it as offices of the NLRB all around the country that do the gritty work of conducting elections and looking at unfair labor practice cases. The General Counsel has directed the regional directors to specifically look for cases involving fact patterns that will best serve his agenda seeking to overturn existing board cases. It's proactive as the National Labor Relations Board has never been before.
It's almost like in the world, I know I use these sports analogies, but in the world of instant replay, it's almost like the referees, instead of refereeing the game, stop, go back and look at the video and say, can we find where Team A violated the rules some way so we can throw a penalty on them?
It's a step beyond that. It's going back and saying, let's rewrite the rule before they run the play.
It's amazing. And Laura Lee, I referenced this a moment ago, and Bob talked about it. We're not talking about taking jobs from Seattle and moving them to South Carolina, which in and of itself shouldn't be a problem, but this is even worse. This is a case where the Boeing Corporation, one of America's most successful corporations, says, we would like to open a plant and invest $1 billion, create 1,000 new jobs in the state of South Carolina, and you have the federal government, through an executive branch action, telling them, no, you cannot do that. This is scary.
And I saw a quote recently on the website of the Coalition for a Democratic Workplace, CDW, and talking about this case, they said this case represents an attack on the basic right of management to determine where to carry out newly acquired business, an indication that the current NLRB has no trouble seeking an order that will waste an enormous investment in South Carolina and cause loss of hundreds of non-union jobs to further supporting a union workforce, because they want this work done in Washington, which is unionized. So clearly they have an agenda here. And what is also an interesting to statistics, there is a Dr. Ann Lane Farrar who works with LECG Consulting, and she was talking about the economic impact of some of this. She was mentioning that for every 3 percentage point increase in unionization, we will lose in this country 1 percentage point unemployment increase. And so just giving the numbers, if an additional 3.9 million existing jobs are unionized, then another 1.6 million workers will either lose their jobs or be able to find employment. So this is raising concerns, especially as the NLRB is attacking companies like Boeing for making these private decisions. Now, there is a bit of good news on the horizon, to the extent that our members of Congress in DC have woken up and have started to take action to try to stop this. There is a bill in the House called Protecting Jobs from Government Interference Act. The site is HR 2587, and it basically would deny the NLRB any power to order an employer to restore or reinstate any work product line or equipment. 2, it would deny the NLRB the power to rescind or reinstate any or change the location of a production line. And 3, it would deny them the power to require employers to invest in particular plants or equipment. So it basically says to the NLRB, stop, this is enough. We can't have you continue to interfere in private business because of what it does to jobs and what it's doing to the economy.
And I think in the next segment we're going to follow up on that. I do want to talk about some of the legislation. Before we get to that, one last comment, Bob. We've got about a minute to go. It almost reminds me as a kid. You remember the game where someone would have a coin, they'd say, well, heads I win, tails you lose. And that's essentially what the NLRB is telling employers, that either you allow the union to determine whether you can relocate resources elsewhere, or we're just not going to let you make that decision at all. And that's just a lose-lose proposition for the employer.
It really is. And there, I guess, are 2 positive things about it. One is it's going to go through the courts. And ultimately, I don't think the courts are going to find that the law gives the NLRB that kind of authority. And as Laura Lee was talking about, there's legislation pending to try to rein in the board.
And we're going to talk about that coming up in the next segment. That's a perfect segue. What can you do as an employer? How should you protect yourself? What are the opportunities out there through the legislative process in which you can engage to try to solve this problem and get back to some more balance, which I think is what most people want. We'll talk about that and a lot more coming up right after this. Welcome back to the AAHOA Educational Experience. I'm Chip Rogers, and with me this week we have both Bob Sullivan and Laura Lee Blake. Thank you again for being with us. We are finishing up a long discussion on the issue of labor relations, the National Labor Relations Board, and perhaps the imbalance that has been created over the last few years on this issue, highlighted by the case involving Boeing. So Bob, we've laid out a pretty good case that employers have some things to be worried about, but what are some of the steps that an employer can take to protect him or herself? And then Laura Lee, what are some of the bills and legislation that employers and people can support to make sure we get this thing back in balance?
Well, there are 2 main avenues, I think. One is, as you referred to, supporting legislation and public input on public comments on pending rule changes. It's very important, and trade associations are a perfect avenue for people to be heard. AAHOA and others, websites like the Coalition for a Democratic Workplace provide tools, grassroots toolkits where people can access prepared letters to congressmen and senators and be heard. Laura Lee's going to talk more specifically about the legislation, but people forget that they can take an active role in the process. And the other thing, as employers, is don't let yourself be surprised, because the goal of what the NLRB is trying to do right now is to try to create faster and faster elections with less opportunity for employers to be heard. So it's important to look at processes, to look around, have a relationship maybe with Labor Counsel, someone that can be turned to pretty quickly to respond to a petition being filed, because it's a very complicated area. It's important to get sound advice.
Laura Lee, we've talked about what an employer can do, but the average citizen can get engaged on the legislative side. You know, through the years, there's not been a lot of legislation dealing with the issue of labor and management relations, but now, because of some of the actions of the NLRB, Congress has begun to take notice. Of course, the representatives in South Carolina are concerned about a company who's wishing to invest $1 billion, create 1,000 jobs, not being welcomed into their state by the federal government. But it's not just representatives from South Carolina. There are a number of other congressmen who have introduced legislation dealing with this issue, trying to get back to a position of an impartial NLRB, which we clearly don't have at this point.
And that is so true, and it is important to continue to follow this legislation and call your members of Congress. With AAHOA, we have been tracking a lot of the legislation. We recently had a congressional day in Washington, D.C. on September 14. I believe we had over 60 appointments with our members, our AAHOA leaders, meeting with their members of Congress. And we were advocating for the legislation that we discussed a few minutes ago, or in the prior session, concerning stopping NLRB from taking action against other employers like it had with Boeing. There's another piece of legislation that's out there right now as well that addresses the quickie elections that we've been talking about, where the NLRB is trying to get legislation or get proposed rules that would allow elections within 10 days, with only 7 days for employers to respond. And that's called the HR 3094, and it was passed out of the House Education and Workforce Committee. And what this would do is it would guarantee at least 35 days before an election could be held. It would also give employees the right to determine how the union would contact them, and they could choose whether it would be through a home address, a phone number, an email address. So there's certain protections that Congress is looking at that would protect not only the employers but the employees. But another thing that I should mention as well, as part of some of the testimony that's been happening before some of the committees as they've been considering this legislation, there's been a number of owners of small businesses that have talked about the need to really reach out to your employees. As an employer, make sure that you have a good relationship with your employees. And I know that's true of so many of our AAHOA members. They own their hotels, they've been working with their employees for years, they go to their kids' Little League games. The employees are part of the family. And if you can maintain that, if you're treating your employees well, hopefully that will also eliminate the need for then any sort of unionization efforts at your place of employment. And as Bob mentioned, kind of the final point is, if you have questions, you can reach out to AAHOA, you can reach out to some of these websites like CDW. They have a lot of material that you can do additional research, and you can contact your local labor attorneys and get the advice from them on how best to address concerns, how to draft your employee handbooks and policies to ensure you're in compliance with the law, but also being fair to your employees. So these are different tactics that you can use to just be prepared.
And finishing on that, because I think that's an extremely important point, is that oftentimes the individual employer thinks, wow, I can't take on the entire federal government. I can't take on the entire National Labor Relations Board. But the reality is there are groups like CDW, AAHOA is part of the CDW group, that, Bob, these groups are out there fighting the fight, and you can certainly increase your strength by joining with others who are concerned about this. And My understanding of CDW and the work they're doing is not saying that we don't want unions, just saying that if there's going to be a union, there has to be a fair, impartial process that is good for both sides equally.
That's right. It's not about just opposing unions. It's about educating employees so that they make informed decisions. And even more importantly, it's about educating the employers, because it is absolutely right that employers should be in contact and in touch with their employees. But it's also an area where they need to be careful, because it's easy to say the wrong thing, things that come across as threatening or interrogation or improper promises or surveillance, are all things that employers can do inadvertently with the best of intentions that can have serious consequences. So I'd encourage employers to go to their associations, to check out sites like CDW, and to really educate themselves about the best way to approach the issue with their employees.
Well, that's fantastic. We are flat out of time. But I want to thank Laura Lee Blake for being with us today, and of course Bob Sullivan. And I hope you enjoyed the show on labor relations. Don't worry, we'll be back again next week with another topic. If you need to reach me, you can email me, chip@AAHOA.com. That's chip@AAHOA.com. Thanks for watching, and we'll see you again next week.